Good afternoon. My name is Megan Sheriff, and I'm Assistant Superintendent for Human Resources for Woods Park Public Schools. I've analyzed the following complaint made by Pat Jones, and the facts this case and subsequent legal ramifications are presented. First and foremost, as a district, we need to look at sexual misconduct under Title VII and Title IX. The rights of Pat Jones as an employee and the protection that she would receive under these two titles are the forefront of this issue. As her employer, we need to address the facts of this case through the lens of these two acts. Precedent has been established, general guidelines for assessing the application of both Title VII and Title IX. First and foremost, Title IX protects individuals on the basis of sex, and Title VII offers protection because of sex. Gender-based discrimination can be classified as sexual harassment, and Title VII is best known as employment law prohibiting workplace harassment. Sexual misconduct is a financial liability for our school system, and strict liability applies if any employee is deemed to partake in misconduct, in which this case, Woods Park could be held liable. The facts of this complaint are as follows. Ms. Jones began working for the district on August 1st, 2019. Ms. Jones identifies as female, and she's the only female in her math department. She heard disparaging comments about a woman's role in the household, but dismissed the initial comment. Further observations were made by Ms. Jones that she claims made her uncomfortable, including a French print that depicts a nude woman surrounded by clothed men. The picture hangs in the department chair's office. Furthermore, Ms. Jones was addressed as sweetie when she brought forth concerns to Mr. Williams in a closed door meeting. Her comment was met with, quote unquote, "You are the only woman. I recognize that there is nothing that I can do about that. We're a strong department and our students do well on state math exams," end quote. On a fourth occasion, a male colleague asked Mrs. Jones if she was planning to grow her hair long, followed by the comment, quote, "I think long hair looks nicer on women," unquote. This remark left Ms. Jones feeling uncomfortable. Lastly, Ms. Jones noticed that her department chair's tattoo, Voice for Men, prides itself on men's human rights activism. Her concerns were solidified with this discovery, and she decided to come forward to Human Resources. As I break down the facts of this case, I'm going to begin with Title VII. There are several landmark cases that establish a lens from which we can analyze Ms. Jones's complaint. For example, in Meritor Savings Bank versus Vinson, 1986, Michelle Vinson sued the bank vice president, Sidney Taylor, for sexual harassment, resulting in a quote unquote hostile work environment. Under Title VII of the Civil Rights Act of 1964, Vinson was covered. She also sought damages against the bank. The court found that, quote, "by proving that discrimination based on sex has created a hostile or abusive work environment," end quote, there is a direct violation of Title VII. In our case, there is not an abusive environment, but it is feasible to think that Ms. Jones could say it feels hostile because she is the only female, and the nature of the comments and culture make it inhospitable and antagonistic. Let's look at the facts of Ms. Jones' complaint. It is vital that we define hostile work environment when we do this. A hostile work environment can result in legal action and collection when the following occurs. 1, an employee is part of a protected class. 2, evidence of unwelcome sexual advances are present. 3, harassment was based on sex. And 4, there's a basis of establishing employer liability. Ms. Jones is indeed in a protected class due to her being female. Suffice to say, the comment by her colleague regarding her hair could fall under the pretense of unwelcome sexual advances. Furthermore, if deemed harassment, it was because of her sex. The comment was specifically tailored for Ms. Jones because of her gender. Additionally, the use of the word sweetie by her supervisor can be looked at as disparaging because of sex. If these instances were deemed unwelcome sexual advances, this is a losing battle. However, it could also be deemed a teachable moment. Additional training on workplace expectations per our county policies would be advantageous in response to these complaints. One question for the legal team: what is our specific workplace policy in regards to harassment? Were all parties involved adequately trained? When was the date of their last training? And are we as a district in compliance with the EEOC in regards to Title VII and Title IX training? Moving forward, our attorneys will argue that the term sweetie was made in a harmless manner, explaining the chair's understanding of her complaint. This is a common colloquial term used in our area of the country, and it was not meant intentionally to be damning. Similarly, Ms. Jones was not dismissed. Her chair focused on what is working versus what is not working in their department. One may also argue that the department is not used to being in the company of women, and it could be argued that they were not aware their speech was potentially offensive towards members of the opposite sex. However, this is somewhat of a skewed argument because ignorance is not bliss in the wake of stringent Title VII and Title IX standards. Furthermore, our attorneys may argue that the colleague's words were meant to be a compliment regarding Ms. Jones's hair. He simply stated his opinion, though it was unsolicited. Furthermore, our attorneys would argue that the painting is not offensive at all. Monet's famous work was groundbreaking because the artist, quote, rejected the status quo of what was acceptable to paint and the rules to adhere to. This is what made Monet's painting appear so risque, unquote, at the time it was made. It is not degrading to women. In fact, it is a celebration embracing gender identity, and its focal point on the woman is, and the woman is the focal point of the painting. They may argue that, quote, although Monet's painting may have appeared a divergent delinquent of the 19th century paintings, the artist had much more reason to place this subject matter with a purpose, end quote. While all these potential counterclaims may have some merit, the main factor that is in our favor is that Ms. Jones took weeks, potentially months, to come forward. Thus, we were not able to as a school division to address her concerns because they simply were not reported. Our attorneys may argue that Ms. Jones seemed to come forward with initial concerns as weeks passed between each incident, allowing for more unwanted advances to take place. Our county has a strict stance on workplace harassment, and had we known early on there was potential for such advances or comments, subsequent events may not have happened. Another point that leans in our favor is that Ms. Jones did not have any job-related consequences, even though some remarks or experiences were off-putting. She did not lose her job. She did not get placed on a performance plan. She did not become ostracized by the group. That being said, there is a case that shows no adverse job-related consequences are necessary when claiming a hostile work environment under Title VII. There's a case that sets the precedent in regards to employees who claim a hostile work environment. No adverse job-related consequences are needed. In Burlington Industries versus Elrith, 1998, the Supreme Court held that employers are vicariously liable for supervisors who create hostile work conditions for those for whom they have authority. That would be the case in Ms. Jones's complaint. Her attorneys will argue that her department chair is liable because he held authority over her, a new teacher. However, our attorneys would argue that there were no job-related consequences, and in this manner is addressed in a timely fashion. Quote, employers may defend themselves against liability by showing that they quickly acted to prevent and correct any harassing behavior and that the harassed employee failed to utilize their employer's protection, end quote. It would be my recommendation that we address the concerns made by Ms. Jones by following the decision held by Burlington Industries versus Elrith. Overall, there is evidence that falls into the gray area. Comments made by the department chair in the painting. However, it is advantageous for HR to address the unwelcome comment regarding Ms. Jones's appearance and the use of the word sweetie. Both fall under the pretext of hostile work environment, especially the comment made by her department chair, as he is in fact her supervisor. Furthermore, Ms. Jones could argue quid pro quo on the unwelcome advances, the hair comment. However, it is more likely that the sheer number of citations fall under the potential of a hostile work environment, which is in direct violation of Title VII. Our attorneys would potentially say the comments were not intentional. However, more attention needs to be paid to these violations. The other area in which we need to look at is Title IX. Understanding Title IX is vital in this case. According to the United States Education's Office for Civil Rights, it enforces other statutes, Title IX, and the endorsement amendments of 1972. Title IX protects from discrimination based on sex in education programs or activities that receive federal financial aid assistance. Title IX states no person in the U.S. shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving financial assistance. The concern in this case falls more under gender discrimination. In my opinion, gender discrimination under Title IX includes any of the following: discrimination, harassment based on one's gender, unfair treatment, attitudes, or behaviors towards an individual based on their gender, gender discrimination as covered by Title VII, sexism, sexist attitudes, and sex stereotyping. And then the final one deals with athletics. Ms. Jones's attorneys may argue that the attitudes and behaviors are clearly established in the department based on comments in her department chair's tattoo. Additionally, quote, sexist attitudes and sex stereotyping, end quote, could potentially be an issue given the nature of the comments regarding traditional women's roles, her hair, and the use of the word sweetie by a supervisor. It is not entirely clear whether these issues would be a Title VII or a Title IX violation or both. On one hand, the original comment was made after hours, off school grounds, in a social setting not sanctioned by Woods Park. However, what she deemed disparaging remarks in incident 3 and 4 happened at department meetings on school grounds during work hours. In regards to the tattoo, though offensive to Ms. Jones, Mr. Williams could claim discrimination if he were sanctioned to cover his tattoo because of sex. While the tattoo may offend Ms. Jones, it may offend Mr. Williams to be mandated to cover it, thus resulting in another Title VII violation. For this claim, I would ask our attorney what our overarching policy is on tattoos and how we can protect employees' rights universally. In Tinker versus Des Moines, it cites that students and teachers do not lose their free speech rights when they enter the schoolhouse. However, Jones's attorney may argue that the tattoo is not a symbol of free speech, but is rather representative of hate speech. The Southern Poverty Law Center deems a Voice for Men a hate group. It explains that male supremacy is a hateful ideology advocating for the subjugation of women in rigid gender roles. It could be argued that this is intimidating, offensive, and hostile towards Ms. Jones. Furthermore, this group is, quote, united by the common goal of explicitly and implicitly oppressing women, and anyone whose gender diverges from rigid heteronormative archetypes, male supremacist tenets also undergird much of the far right. That is cited from the Southern Poverty Law Center. With the understanding of this tattoo, I would want to know if the attorney feels Mr. Williams' display of this icon is suitable in the workplace given our current county policy. In summary, my analysis suggests that we are in a precarious position with both Title VII in regards to Ms. Jones's complaints and Mr. Williams' potential counterclaim regarding his tattoo. We need to look closely at our county handbook regarding sexual harassment and free speech for employees. That being said, it is my opinion that the court will rule that we are indeed in violation of Title IX, giving the disparaging remarks made towards Ms. Jones, the painting displayed in the workplace, and the language and comments used by the department in departmental meetings. It is my recommendation that the members of the math department be addressed who are in violation of Title IX and would be found responsible for their words and actions in a court of law. If you have additional questions, please do not hesitate to contact me at Human Resources. Thank you for your time.